compliance. Carrying out reforms to abolish charges and properly collect maintenance would not only benefit parents with care by receiving their maintenance in full and on time, it would also be a lifeline to allow low-income families who would be lifted out of poverty. A culture of non-payment has developed. Parents are failing to make full and timely payments because the child maintenance service is allowing them to. The UK government is allowing them to. As Gingerbread have said, children living in single-parent families are almost twice at the risk of poverty compared with children in coupled families. Victims and survivors of domestic abuse should be protected by the UK government, not punished financially for their inability to engage with their abusive ex-partner. It's clear that the UK government remains wedded to austerity, that this is in stark contrast to the efforts of the Scottish Government's determination to create an inclusive, equal Scotland. I call upon the Minister to follow up on the Gingerbread recommendations. I won't go through them because I've actually done this already in my speech, but they are very easy to access and there aren't a lot of them, but they would make a huge difference to parents with care and more especially, please, make a difference to those children. The CMS what they do is insufficient, inefficient and they're incapable. Our children deserve better.
I thank the Honourable Lady. The question is that this House has considered the child maintenance service. There are 3 backbenchers trying to catch my eye, and the front benchers really cannot start the wind-ups later than 12:30. Antoinette Sandbach.
Chairman, and may I thank the Honourable Lady for Motherwell and Wishaw for calling this debate. I should perhaps put on the record that I have used the Child Support Agency for the last 13 years, and I would liken it to banging my head against a brick wall for most of that time. I also spent 4 years as a caseworker supporting parents, particularly with the Child Support Agency, the predecessor to the CMS, with their cases because of my knowledge, my own personal knowledge of the procedures. My experience is that staff are not properly trained, that particularly the CMS staff, since the move over to DWP, have no idea what their enforcement powers are. They are extremely reluctant to use them. They fail to use them regularly, and there's a lack of proper compensation when mistakes are made by the CMS. Now, I appreciate that the volume of complaints to my inbox in relation to CMS is relatively small, but that's because the vast majority of 3 million cases are still working under the CSA system and have not been transferred over to CMS yet, which in my experience is probably a blessing in disguise. I know that it is not the fault of this minister, and I feel very sorry for this minister because she's taken over a system which has had systemic failings for years. And the fact that £4 billion worth of arrears are outstanding demonstrates the catastrophic way in which single parents in this country have been let down by a system that was supposed to make collections easier. Now, the Honourable Lady for Motherwell and Wishaw has outlined very ably some of the key problems and the recommendations of the Gingerbread report, and I'd like to concentrate specifically in relation to avoidance by the self-employed. As we know from the Chancellor's statement recently, a vast number of people are moving over to self-employment, and that is a growing group, particularly amongst non-resident parents. And it makes the avoidance of child maintenance that much easier. There are online forums which provide advice to non-resident parents in how to avoid child maintenance payments, and quite frankly, the government have not stepped up to the plate. It is absolutely scandalous that parents whose legal rights to maintenance for their children have been taken away and given to the state are finding that the state is unwilling or unable to enforce their rights. And quite frankly, it's not good enough. In my view, it is discriminatory because it largely operates against women. 75% of single parents with care are women. And the government really has to look at this area again. So I would call for some specific action by the Minister. In particular, I would echo calls for the lifestyle inconsistent with earnings. It is absolutely ridiculous to suggest that a parent who may have separated from their partner 10, 13, 15 years before would have a detailed knowledge of their financial circumstances. And very often the only evidence that is available and that can be shown to the Child Maintenance Service is lifestyle inconsistent with earnings. And I have a constituent, for example, who left his wife, set up with another partner. There was a Range Rover, foreign holidays abroad, and £33,000 worth of arrears. Eventually, after a long court case and tribunal hearing, and the matter had to go through the tribunal hearing, but the evidence in that case was lifestyle inconsistent with earnings. And it really is vital that that is reinstated. Secondly, the government needs to look at how tax rules are used to disguise assets, and in particular where someone is self-employed or a director of their own company and they make a director's loan into that company. That is an asset that is owned by them. It means they can take large amount of money out of the company, but it is not considered to be an asset for the purposes of child maintenance. And that's wrong. You know, that allows abuse of the system, and quite frankly, it's being used a lot. That information should be available from Companies House. It should be available from HMRC, and really it needs to be looked at again. The further recommendation I have is that the government considers giving women an enforceable right in the courts where there's a threshold of assets. Where that asset threshold is set, then that's a matter for the Minister and her team to decide. But I would urge you that where there are circumstances where there's over, for example, £500,000 worth of assets, that case ought to fall outside CMS. They are not taken into account. The family home, for example, is exempt from consideration as part of the assets of the non-resident parent. And it doesn't take much to look through past cases of that have been through the tribunal system where there are assets of several £1 million in the family home, in expensive sports cars, in other high-value items which simply cannot be taken into account by CMS because they don't generate an income. But it is a very convenient shelter, and it allows high net worth individuals to avoid paying for their children. And again, I would say that it is really important. The women involved in these cases have no other way of enforcing their rights. You have taken the rights away from them in court, and really they need to be reinstated. Quite frankly, because failing to do so, because you've excluded so many assets from consideration, and actually you're not reflecting the real ability of those non-resident parents to pay for their children. I referred earlier to staff not knowing their rights. There's a complete unwillingness from the CMS to, for example, request data from the Land Registry, and I would certainly support co-location of HMRC and CMS staff. HMRC should automatically notify CMS if there's an increase in a non-resident parent's claim for tax relief. If they put in a tax return and they're claiming up to the tax-free allowance in terms of income, that should automatically be notified to CMS, and we should have much more effective data sharing across government to enable enforcement. I could go on, Mr. Chairman, for longer, but I would say that having been a single mum for 8 years where I fought the system, having been a lawyer, who thought that I could understand and work the system, and I'm a member of Parliament, and still we cannot get it to work. It is really a scandal and a disgrace that lone parents are being let down so badly by a system that allows non-resident parents to manipulate it. So I'm very grateful for this debate, because it really, if we are to be a government that is there for everybody, then we must be a government that supports those who are the least able to enforce their rights. And the fact that their legal rights have been taken away means the burden and the responsibility on government is that much greater, because they have no other way of doing it. And I know that a judge in the courts would, having practised for 13 years or more as a barrister, I know that a judge in the courts would look at these things in a very, very different way from government. And quite frankly, it's time to give more the rights back to women to take them through the courts, or to make sure that staff are properly trained, that they take the action that they need, and that they enforce appropriately. I note that the Minister has £3.9 million worth of arrears outstanding in her constituency. Mine, regrettably, is £5.4 million worth of arrears in mine. And I would say to any single parent that is reading this debate, that is my constituent, or indeed any single parent who's looking at this debate, please contact your MP. Allow us to try and help make the system work for you. But when CMS does make mistakes, it should compensate appropriately. And the compensation regime for CMS has changed since it's moved over to the DWP. Now, that's wrong. And I suspect that we will be seeing some parliamentary ombudsman reports in relation to claims against the DWP for maladministration. But it is unacceptable that where mistakes have been made by the department, that it is the children that have to pay for it.